Good morning, everybody. Hello to you all. I hope that you are all well. Welcome and thank you for joining our webinar today on record keeping. My name is Paul GIbbons and I'm the founding director and chief executive of Decipher Consulting. The webinar today will consist of, it's going to consist of 5 speakers, but I'm going to have to give an apology for one of them. And we're looking at the challenges of record keeping. We're looking at issues as we see them through the lens of a consultant, a solicitor, and a barrister. At the end of the session, there'll be a panel discussion, and we will welcome any questions you may have to the panel. I'm pleased to be joined on the panel today with Annie Clift, who's from Limeslade. Annie will be moderating the session. My apologies for Charlie Woodley. He has not been able to make it today.
He's here now, Paul.
Apologies. Hello, Charlie. Hi, Charlie. Apologies. Yeah, Charlie Woodley. Good morning. He founded Dispute Data in 2019, a specialist consultancy that provides technology and informatics expertise to engineering and construction teams. He provides analytical services to those faced with the challenges of claims or disputes within engineering and construction claims and dispute resolution. And the technology represents the single greatest opportunity to achieve time, cost, and quality. Charlie will address those challenges for his clients by combining sector insight with leading document processing solutions from the world's legal forensics and document capture providers. I'm also joined today by Hannah Mycock-Overell, solicitor. Hannah is an associate in the Construction, Engineering and Environmental Projects Group at Clarkslegal, based in Reading. Prior to joining the firm, she helped set up a legal consultancy targeted at SMEs in the construction industry, with a focus on risk management and dispute avoidance. Hannah believes that contractual risk can be best managed by having the right advice at the right time, from advice on procurement strategy and contract negotiation, through operation of contractual mechanisms to enforcement and, if necessary, dispute resolution. I'm also pleased to be joined today by David Johnson, barrister and Tech Bar accredited adjudicator. David practices in the fields of domestic and international construction, engineering, energy and information technology at King Chambers. David has been involved in numerous transport and infrastructure disputes, including several UK and international railway and urban railway projects. He's also acting as sole counsel in multiple disputes in relation to capital expenditure expansion programs at international airports. He advises and appears both domestically and overseas, principally in the Far East and the Middle East, and worked last year on the Philippine power dispute seated in Singapore. And finally, but by no means least, I'm also joined today by Brian King. Brian has over 30 years of experience in IT. He has written a number of successful commercial software products before helping to found Afterpremise. He worked for Oracle, where he advised some of the world's largest asset owners and engineering and construction businesses on enterprise program management solutions. So that's the panel today. As you can see, it's well educated and well informed. And without further ado, I will now pass over to Annie, who will moderate this session. Thank you.
Thanks, Paul. Welcome, everyone. Thank you for joining us. Today, we're going to have a look at record keeping. It's been a major theme of a lot of the advice and webinars and articles and things that have been cropping up around the COVID situation. But we're going to kind of take a deep dive and look at what is good record keeping, because it's quite easy to say, get your records in order, but how you do that is a little bit more tricky. So we'll start with you, Paul, and kind of just ask the big question. What does good record keeping look like?
Well, this is one of the most difficult questions to answer, I guess. But some advice I would suggest could be found in my ex-boss's authority, Keith Pickervance, on delay and disruption in construction contracts. And it's particular around programme records, where Keith was suggesting that the contractor should ascertain the planned timing of the works in the absence of the occurrence of any event. He also suggested that by referencing what has already been achieved, consider the planned timing for the future conduct of any work and whether this is realistic and practically achievable at the time of the event. This is an interesting one in so much as we're working on a situation at the moment where the planned activity pre-COVID-19 for one of my clients was they're getting 0.8 productivity. and now they're getting 0.5 productivity in their post-COVID-19 works to complete. So making reference to planned timing before COVID-19 and after COVID-19, and the records around that are going to be quite detailed. We also, Keith suggests that the nature and timing of records and how they are kept in relation to time risk is important, and particularly around the adverse effects on planned activities, and also the calculation of the planned timing of matters and how this affects the completion date. But more importantly, records should be kept both on and off the site. So where you've got site-based records in a physical construction site, that's all well and good, but what about the off-site fabrication of matters, and who's maintaining those records? But for me personally, good records are where you say what you plan to do, and you record what you actually did, and you reference simplistically the cause and effect of any changes, demonstrating either the employer and, importantly, contractor culpability. This will make your record keeping credible. In the past few months with COVID-19, we've seen experiences of quite poor record keeping, and predominantly that's because people haven't been available to maintain the records on site. But also weekly records, for me, should look at the programme. How is that updated? Is that weekly? Is it monthly? You should always go back to your contract. I think the record needs to look at the baseline programme and the updated programmes. How are they maintained? In what format? Progress records. So have you got as-built data on and off the site, as I've said? And how are they maintained? Are you looking at site allocation sheets, daily diaries? Are they legible? Have you got the people maintaining them? Resource records is another area where you look at the management of the activity, the labour, the plant, the equipment, the materials, the subcontractors, their outputs, their productivity. All of these are elements of good record keeping. And of course, the record is nothing unless you can get paid for that particular delay or disruption. And for that, you need good cost records. And again, it's going back to your labour, your materials, your subcontract records, your indirect, your overhead costs. So a whole raft of stuff there around demonstration and collation of that. And then all of this needs to be collated in correspondence, whether they be administration records, emails, letters, notices, instructions, and the like. So in essence, that is a whole gambit of what good record keeping. There's no one size fits all, but as I say, there's a whole myriad of stuff there that we need to be considering.
Thanks, Paul. So there's a lot to think about there, lots of different records that need to be kept. Hannah, how does the structure and organisation of our records make a difference? Oh, you're still on mute, Hannah.
Yeah, I was saying it's really critical that records are well organised and properly structured. Obviously, Paul's just talked through a lot of categories of documents and information that you're going to want and need to keep on any one project. And if that's just kept in, for example, a chronological order, it's going to be really difficult to pull out the information that you need, whether on a monthly basis or in relation to a specific event or theme. I mean, my sort of key tips, obviously it's going to vary company by company, and the key thing is finding something that works for your organisation and that you can maintain and replicate project by project. But what you really want to be looking to do is categorising your records. General or miscellaneous ideally wouldn't be one of those categories. So you'll have your financial data, but then within that you'll have subcategories. You'll have your time program delay data, and within that categories of documents and records. So your regularly updated programs, you'll have categories for each specific delay event. And whether you do that via folder structure or whether you do that with consistent keywords in documents, that will all depend on what your setup is and what works for you. But the critical thing is having that structure and categorization so that when you need to pull together your records on any one topic, you can easily get those together swiftly and easily. Another thing I'd suggest is really helpful is actually keeping a record of your records. It sounds like extra work, and to a certain extent it is, but if you have a log of what records you have and when they were last updated in each category. That allows you to easily see whether you are keeping your records up to date. And it also, if someone's reviewing that, it lets you see where any gaps might be, and then you can fill those gaps close to the time of those gaps happening, rather than months later trying to fill in and work out what happened on site in the second week in May, because no one actually remembers, and that whole slim folder of paperwork's gone missing potentially. Keeping those records under review with that log also means that you can make sure that things are staying in the right categories. You make sure that you haven't generated a general or miscellaneous category that things have just been getting dumped in. It's really easy to do that. But the problem with not having that structure, or not having a properly maintained structure, is that when you need to pull records together, the risk is that when you need to make submissions under the contract, you can't pull the documents together in time, which, as we'll talk about later, can have potentially really quite serious ramifications. And also, if you need to seek external advice, what you want to be able to do is to say, well, this is the bundle of absolutely the key documents on this topic, rather than doing a mass dump of, this is everything from my delay program folder, please pick out the information, because all that's going to do is delay you getting advice, and it's going to prevent that advice from being as cost effective as it could be.
Thanks, Hannah. Paul, Hannah mentioned there about how difficult it can be if you're having to look back and fill in the gaps in your records. Contemporaneous records are really important and the best records you can have, but how do you balance that, keeping those records, when you're under the tight pressures of running a project?
Absolutely. I mean, it's even more so in the last few months, when particular construction projects where staff have been furloughed. You know, you need to maintain a balance of collating those records contemporaneously, having the right people on site to do that, understanding exactly what records that need to be maintained. But of course, it's easy enough to write down a list of things that the contractor needs to demonstrate through the records, but it is quite a different matter to ensure that as a contractor, or indeed a developer or subcontractor, that those records exist or indeed are available for retrieval. I personally believe that most employers should be saying at the outset what records they believe should be maintained contemporaneously, because that would then ensure that the contracting organisations would man up sufficient resources to allow those records to be maintained, because we see it every day. All the potential disputes and matters that come on my desk, we see that the contractors haven't maintained the right records. Why is that? A couple of things: they haven't necessarily had the personnel, the resources to do so, but also they haven't known what level of records to keep and to what onto what level. So the records for me need to be simple. They need to most definitely refer to the site diaries, the work allocation sheets, and indeed these should be maintained daily. And that's a difficult matter, because when you're on a live construction site and you're putting the responsibility on a supervisor who's managing a team through the day, the last thing that supervisor wants to be doing at the last thing of the day is completing an allocation sheet or a site diary. But it needs to be undertaken. And I think technology should come into this to make the record keeping and the collation of data much more simplistic and much more efficient. But whatever method is used, the most important thing is to record information that can identify what was being achieved, what was planned to be achieved, and why there's a difference. And in an ideal world, we would like to see this linked back to activities within the programme. That could be done after the event. I appreciate that it's a nice to have. Not all organisations at site will understand what activity has been impacted, but you need to understand and have that information available for after the event to record it. The CIOB, they provide some good guidelines around what effective record keeping might look like. And it mentions, describing the activity, the date of the record, the resources used, start and finish dates, the author of the record, any progress data. So all pretty much common sense information. And to that, you might like to add location, effect, impact, and so on and so forth. But the purpose of the record keeping should not just be to be complying with the requirement. And we ought to consider how these records might at some point in the future be used. And as I say, in these difficult times, and indeed moving forward, the collation of those contemporaneously by the right personnel is required. But as I say, I think it needs to go back to the employer driving that change moving forward.
Okay, and you mentioned their technology, so we'll come into that. Technology is allowing us to create more and more records, but sometimes, is there any way to make sure that the ones that we're creating are useful and how valuable they are?
I think in terms of the technology around the records that are being maintained, I would particularly like to see technology being used in how we collate notices. So obviously a lot of contracts put a lot of responsibility back on the contractor to put notifications in time, otherwise there's potential condition precedent time bars on there. So notifications, as I say, that's the first one. You then need to update your program and on a weekly basis, I would suggest. And for that, we will be utilising technology, possibly by way of drones, to capture progress on sites. So that can then feed back into like a 4D modelling of the particular project. And we, prior to the COVID-19 shutdown, we had a particular situation where a client had done a full video of the site progress up to COVID-19, and indeed is continuing that post. So it's utilising drone technology to capture data whilst also respecting the social distancing requirements. So that's a good use of technology. And I think in terms of how you then maintain that technology, it's got to be, utilising the information on a daily basis, perhaps marking up drawings, utilising photographs, as I've said, and then how will we utilise that data moving forward. But don't go too far, avoid overcomplicating things. An inbox or document structure organised by project can be ruined by overthinking the structures needed. And normally it won't be necessary to break down folder structures into many subfolders. So for me, you've got to keep it simple. Ultimately, the crucial thing with the use of technology is to be able to retrieve and sort and filter the vast amount of information that's going to be maintained on construction projects.
Cool. And Charlie, those vast amount of data and the kind of large bundles of records, are there any ways we can work better to handle them when they are received?
Absolutely. I guess one of the kind of it's almost human nature to want to reorganize what someone else provides to you, and it's a very common pitfall, shall we say, to receive someone else's file structure, but to want to put your mark on it, to try go through and reorganize it. Particularly when you're dealing with someone else's file structure, quite often there's meaning to it. So before one deconstructs it and puts it into kind of a flat file structure that's quite common with document management platforms, you want to retain the hierarchy in there in the metadata, so that if you find out that there's a nugget of particular information from a particular custodian, which is quite common, you know that Fred Blogg's laptop is the place to go. You'll have to excuse my 3-year-old in the background. I think my wife is probably chasing her up the corridor. So I guess one of the classic ways things go wrong right from the get-go is people will just try and copy a gigantic nested folder structure into their own nested folder structure somewhere, and then it's obviously laden with kind of long file path errors, and people can't really understand why they don't see documents that they expect. A classic symptom of this kind of thing is beautifully named folders with no files in them. And this problem isn't just when you receive files externally. Quite often, in recent years, where companies have migrated to cloud storage solutions, they've copied their own files from a file server to a cloud-based solution, and huge swathes of their documents go missing in the process. And there's not been any kind of internal basic kind of checking procedure to say, well, I started with 10,000 files and I've ended up with 10,000 files. So a good part of this is just kind of common sense to go, okay, well, if I'm still thinking about things in terms of basics, if you're a QS, you are going to add up your column to make sure that it makes sense. Likewise, when you're dealing with quantities of documents, it's very easy to turn around and say, well, I started with this amount, and have I got the same amount when I get to the other end? So that's kind of like early doors, is just understanding the risks of moving large numbers of documents. I'm sure others on the call will tell us the wonders that cloud solutions can now do with your documents when they're there. I guess from my own background, as in how do you do something with a document that you thought you were going to be able to do, but then you found out that you couldn't do it. So this probably goes back to what Hannah and Paul have said before. So there's two kind of key things that are underlining this, is whether you even know what's there in the first place, and this idea of understanding your own information architecture and how it works, and how you move information from within one business unit into another, and how, in theory, somebody sitting on the board wants to have a total picture, how they pull information from those different business units. And if you can ingrain that kind of understanding into people that work with dispute data, then it informs how you ask for information. So rather than writing out a list of documents paper that have the following information in it, and you will get PDF copies of bits of paper, what you really want is the structured information that sits behind those records. So this is where the understanding the information architecture of your own business, most businesses are fairly similar. So once you've understood it from your own perspective, you then understand how to kind of make a digitally informed information request. I think that's kind of a fundamental to knowing what you shouldn't do to the information that you get that comes the other way. So it's kind of a neat little feedback loop, where if you kind of think it through in those processes, it makes it much easier to request, receive and process information and try and get to where you really want, which is obviously some form of information, some knowledge to come out of it.
Thanks, Charlie. And Brian, in terms of the type of technology that we have available, what is around to help us manage these documents?
Oh, well, sadly, I'm going to contradict our previous speaker by saying use the cloud and don't use anything else but the cloud. My advice for everyone is to follow Isaac Newton's advice, and that's to stand on the shoulder of giants. The shoulders we picked was Amazon's cloud platform, and it does simple things for us that we don't have to try very hard to achieve. When I store a database record, it gets copied twice to two separate data centers automatically, so it's very safe. I can restore data in my database to any point in time in the last 35 days at the touch of a button. And when I drop a document into Amazon, it's copied across at least 2 data centers automatically, which means Amazon can give me a service level agreement that if I store 10,000 documents, I'll lose 1 document roughly every 10 million years. So just from a basic information management, stand on the shoulders of giants. That allows me to sort of concentrate on more interesting stuff, which is really trying to get more people to participate and give us records so that we've got better record keeping from everyone. And again, Amazon lets us do that by essentially running the service we provide without any permanent servers. Now that sounds a bit mad, but it means our software just stands up, executes and goes back to sleep again, which means we only charge when it does work, which means we don't track any user licenses, we don't charge people expensive user licenses, which means we get more information from people. On top of that then, the other interesting thing is consistent repeatable outcomes. People have come back and said standard structures. Yes, we have standard structures, but not only do we have standard structures to allow people to start a project the way they mean to go on, but they've already got baked in standard keywords and standard document type. So for a section of a manual, or for a section of a document in a folder, we can say we want a PDF and we want the original XLS file, and we will manage them as pairs to make sure we don't lose any data by converting it to PDF. And we find that's quite important. The other thing this allows us to do by standing up these structures up front is it allows us to inform everyone at the start of the project what's expected of them and what data we want from them, which means we don't get any arguments about, oh, I didn't price for that, and all that sort of good stuff that we hear all the time. And it also means that the software can go get the documents through automated processes while our contractors are on site, which tends to reduce the overlap. We get quite a lot signed off early and checked early, which means we don't get this huge data dump at the end of the project, when frankly everyone's running around with a spurious record. You can't delete something from the chain and you can't add something to the chain. So we end up with something that's traceable, trackable. We can see what we've got, we've predicted what we're expecting, we're tracking that we're getting the right types of documents, and much more important, it's neutral and immutable. So the arguments start to go away. That's really what we're trying to do with technology.
Thanks, Brian. Apologies there. I just lost my connection for a second, but back now. Brian, the other thing I was going to ask you about is emails are a particular problem. You quite often see whole inboxes dumped. Is there anything we can do to deal with correspondence and managing that?
Yeah. I'll break this down into two parts, because I admit that everyone gets dumps of emails and huge dumps of emails, and then says go sort that out, which is a real pain. But then I'll come back to a point on two projects that I've dealt with personally, where they've actually tried to, from day one, reduce the use of emails just from the start of the project. If I was trying to solve this problem, I would probably try and push it up. I'll keep saying Amazon. I would try and push the documents up into Amazon, even if it's the EML files, do some sort of conversion, and use a project called Textract. And Textract, basically, we use Textract to do full document index building. So every document we load is fully indexed for every word in the document, and try and pull out themes and patterns. The Textract has got a little bit of AI built in that will help you manage and spot patterns within emails, and that's really only going to sort you out the wheat from the chaff. There's a better bit of technology further downstream called SageMaker, and something called XGBoost, and that's a categorization algorithm. And really we'd just get to, if Hannah was running through looking for just categorizing emails into that's evidential and that's not evidential, we would get it to learn from Hannah what she was doing, which means every time, the next time she did it, we would reuse that algorithm and that training data first before she started to get involved, and try and get it better, cleverer and cleverer at just predicting and preempting what she would pick from the data. If you think about that technology now, the NHS is using it, where it's as accurate as 2 radiographers in spotting cancer, but it runs at massive scale, so it's just much quicker. So that's the kind of technological ideas I would bring to that sort of party. But for me, 2 projects stand out that have got away from emails almost entirely. One was London 2012, and a woman there called Donna Rees of CH2M Hill. She asked us to help while I was at Primavera before the Oracle acquisition, and we put a product in there called Contract Manager, which was just a big change control funnel. And the instruction was really simple. If you get an email asking about change, just direct them to the contract management solution and put something in there as a notification or something. And a dictator that really concentrated with minds, if you didn't have a contract management number, you weren't going to get paid. So that was really quite simple. That sort of clipped most emails off at the knees. A similar approach with a French guy called Bruno Chimino of Cosia. Those guys built the Tour to Bordeaux TGV line. The same diktat, but they used a portal solution. So again, but was just one big funnel collecting any change or anything so that it could be managed in one place using one process. I sponsored that project. I thought it was fantastic, really successful. I sponsored that project for an Oracle award. They won Project of the Year in Oracle France across all industries, which was amazing. And they also won the Global Construction Award at Oracle that year for best construction project run globally on our solutions. So 2 different tools, a similar idea on day one. Let's try and stop emails, and the common thing, those 2 projects have 2 things in common. They were both on time and on budget. So I think spotting projects who are thinking out the box about trying to inhibit emails would, for me, give reduced risk and would be a good indicator that they're actually going to be run properly.
Great, that's great. And Charlie, on those projects that do have lots of emails, lots of records, when we get into a dispute situation, how does this oversupply of records lead to the cost? They lead to the cost shooting up, and is there a way the format of records can make a difference to this?
Absolutely. I guess, again, I think probably before I mentioned human nature is to organise things, and in dispute the world, quite often that means reading information is a default position as well. So whilst it's tempting to kind of do your records, if you think that you're then paying for them to read them when they don't need to, that's quite a good control to make you think twice before you actually disclose certain records. So fundamentally, the cost comes from people, and what is it that we're going to do with the records that you provide. So I guess this idea of is there some form of structure? So kind of 20 years ago, you'd walk into a client, a contractor's office and say, well, what are the records relating to a dispute? And they'd go, well, it's these 10 A4 lever arch files. And actually things were fairly well organized. It's slightly ironic that in a digital age, things are actually less well organized, I find, because there's a bigger opportunity for things to dissipate within a business. So actually finding the true consolidated set of records can be quite a challenge. So I guess in terms of the pure cost is, when engaging an external partner to look at records, one of the questions that I would recommend people ask is, how do you process records? Do you have a formal process for how you manage information coming into your business, what you do with it to ascertain what you've received in the first place? It's actually fairly uncommon for somebody to say, thank you very much for sending me that hard drive. By the way, these are the list of files that were on it. Was there anything else you wanted to give me? It seems like quite a basic thing, but people tend not to do that. They just dump files into an ever bigger kind of pot, wherever that might be. And I guess when you examine, this kind of goes back to some of the earlier points about what is good record keeping, because keeping a record that's got useful information in it, but the only way to get it out is to manually type it out again, it questionably is not good. People need to, organizations need to understand how information flows through their business and what the level of effort and therefore the cost is of making information work for them. Obviously that's reasonably within your control when you're dealing with your own records relating to a project and in a dispute. Obviously when a third party hands you their records, then really it's just about having the right kind of tools in your box. Having the understanding of when to reach out to external solutions to fast track particularly difficult elements, and perhaps picking up on the emails being the previous thing. If somebody gives you 100 PST files, which is millions of records, it's inconceivable that at dispute resolution rates that someone's going to start opening up those mailboxes and reading emails one at a time. There are tools, depending on how much of a hurry you're in, what the time constraints are. You can go to the kind of forensic tools of kind of Nuix and well, I think Nuix bought Ringtail, so that's now part of the Nuix family. And you can basically use parallel processing to scale the processing of those incredibly quickly if you need, terabytes within weeks if you need to do so. However, if it's more of a kind of a claim preparation scenario, we've got the time. Actually, for example, Amazon and Textract and the like, and other AI providers like Manoia or AmpWorks, you can get them to process the records so that you can then understand what elements of data extraction you can automate. And I think this is kind of probably where the biggest cost saving comes, because when you commit to a fact that you need to extract certain tables from certain documents and you need to do that over a certain period of time, it becomes very easy to calculate the human cost of that manual data extraction. realistically, in this day and age, with advances in OCR and document capture technologies, most manual data extraction can be automated to a degree. And it really does depend on individual documents. It's rare that every document is of the same quality, so that there needs to be an understanding for how these solutions work and where their limitations are, because nothing is exact. There'll always be an element of human interaction and checking that goes with it, but it can make a huge difference between, so I'm working on a dispute at the moment where the opposing expert has relied very heavily on sampling and extrapolation. And in principle, his entire valuation for kind of $200 odd million is sitting on a very sliver thin analysis of, I couldn't turn around and actually price this because there was too many records. So actually our first defense is just me going back and going, well, we could have done it. We've estimated, kind of completely undermines the justification for quite a convoluted and what I would call a sloppy valuation. So that kind of strategic advantage in dispute proceedings is something to bear in mind, and it's one of the reasons why people that are having to handle that higher volume of documents really should consult with people with some expertise in that field, to understand what the opportunities are, not just from expediting their own analysis, but actually from challenging the opposite side as well.
Thanks, Charlie. Hannah, going all the way back sort of to the beginning, does it make a difference what contract you're using as to how you should be handling and keeping your records? Your mic's on mute again. That's well.
There we go. Yeah, I mean, potentially it does. The contract, regardless of which form you use, is really relevant in three ways. One, it may well have obligations to keep certain records. So I think it was Paul was talking towards the start about actually the employer saying, these are my requirements for the information and the records that I require you, contractor, to keep on this project. There will also be obligations in the contract to provide information at regular specified points. So normally with your payment applications, you've got an obligation to provide information to substantiate that, which you're going to have to draw from your records. Information relating to the programme and then any delays. And then also you want to keep records that demonstrate that you've complied with your contractual obligations. So these will be clauses that don't say, and you must keep records or you must submit records to prove this. But if you ever need to prove that you've complied with that obligation, you need to have the records there to be able to do so. So the starting point really is to look at your contract, whatever form you're using, and see what it says. And that should guide what records you need to keep. You will obviously, on any project, you're going to want broadly the same categories. You're going to want your financial information, you're going to want your program time information, you're going to want your resourcing information, but potentially how you structure that, potentially the keywords that you put in that might be guide to allow you to draw information as needed, might be guided by the obligations you've got in your contract. And so within the standard forms, there are differences. So in terms of the programme, under the JCT, you haven't got obligations to regularly update your programme. Obviously, for your own management purposes, you're probably going to be wanting to do that anyway, but there is no procedure in the contract that says you must, at these intervals, update the programme and have it approved. Whereas obviously in the NEC, you have got that specified process of providing the programme at the outset and then regularly updating it. Again, in terms of delay or claims for loss and expense under the contract, there's a difference between the forms. So in the JCT, you have to notify the employer of progress being or likely to be delayed with the causes of that, and you have to give an estimate of how long that delay is likely to be, which means you need to have the records there to be able to give that estimate. you have to update that estimate if there's any material change, which means you need to have the records that are tracking that and flagging to you if there's any material change, so that you know whether you need to give that information. And then also in that same section of the JCT, there's an obligation for the contractor to use best endeavours to prevent delay. And that's one of those obligations that I was talking about, where you want to have the information available to be able to demonstrate that you've done that. It doesn't say, and you must submit records to the employer to show that you are using those best endeavours. But if it comes to a claim scenario, you're going to need to be able to demonstrate that. So you're going to want information about what steps you took to manage that delay as best as you could. The NEC obviously is a much more structured regime for giving notices of claims, and those notices actually are conditioned precedent, so it's a much stricter regime as well. The contractor needs to give notice of a compensation event, assuming the project manager hasn't notified it, within 8 weeks of becoming aware of it. And if the contractor fails to do that, then they can't claim that compensation event, so they won't get that extension of time, they won't get that increase in the prices. I won't go into sort of the details of it, but there's then another time limit of 3 weeks for the contractor to give an assessment of what that impact on the completion date and on the prices is going to be. And that whole regime of compensation event notices also interacts with the NEC's early warning regime. So the early warning notice that the contractor has to give isn't itself a condition precedent to being able to make the claim. But what the NEC says is that if the contractor doesn't give that early warning notice saying this may impact the time, this may impact the prices, as soon as they become aware of a matter that could have that impact, then the project manager is entitled to assess a subsequent compensation event, assuming that a compensation event is subsequently notified, as if that early warning had been given, i.e. as if that early warning had been given and they've been able to mitigate the delay, they've been able to mitigate the cost increase. So with the NEC, it's really important that you've got almost sort of slightly more live records. You've got to be more proactive rather than reactive. With the JCT, you can sit there and sort of say, well, this has happened and now we need to notify it. Although it says in the JCT that you should notify it when it's likely to cause a delay, there's no actual real consequence for waiting until there is a delay before you notify. Whereas in the NEC, the emphasis is really on you have to do it within certain periods and you have to be proactive and you have to keep on top of things.
Thanks, Hannah.
If I could just jump in there.
Yeah, of course.
Just to add 2 points that I think are perhaps worth bearing in mind. A number of contracts have provisions that enable, for example, the employer to demand certain records from the contractor. Those most obviously might relate, then there might be specific obligations in relation to program updates and so on, but equally working documents and various updates. And I think there are 2 points to observe there. One is at the outset, it's prudent for employers to consider whether the contract form that they're considering offers enough in that way of protection for them, that ability to demand such documents. And if not, they might want to consider drafting bespoke amendments that, if you like, beef up those powers. The second is the number of parties that have those sorts of provisions in their contracts and don't use them and don't make use of them, even at times when it's becoming painfully apparent that a contractor or a subcontractor is failing to keep or indeed to submit the contractor was keeping and how they were keeping them. It means that you're not sort of groping around in the dark, and you've got a little bit of an idea of what you should be expecting to see, which means that you can tailor your requests to be a lot more specific, given that, as we all know, tribunals, courts, arbitral tribunals don't like generic requests for all of the records between a period X and Y and so on. So I think that's just perhaps something that I was going to add there. Obviously, also, Hannah has touched on the different provisions in different standard forms. Lots of different contracts, NEC, FIDIT, ICE, JCT, all have various conditions precedent or clauses that look like conditions precedent for the notification of claims. FIDIT one is particularly interesting because in addition to the original notice, the contractor must be required to keep such records as the employer may demand, and indeed the necessary records to substantiate the claim. And there have been what these clauses don't really do is say exactly what sort of records they are. And there's been a little bit of law of this in the past. And I was just going to mention very briefly the relatively well-known case, the Attorney General for Falklands and Gordon Forbes case, where under FIDIC, I think it's a 1987 contract, so it's an earlier version of the relevant provision. The contractor hadn't actually maintained the contemporaneous records, but tried to do it by way of witness statements and effectively sew it all together there. And the judge in that case said, no. The emphasis is very clearly on contemporaneous records. You can't go back and write up the story later on. And in that case, the claim failed for want of the relevant supporting information. So again, these conditions precedent give you a steer as to what sort of level of documentation and what type of documentation is going to be needed under your particular contract form. And if you don't look at it at the outset, the chances of you making a mistake and going down the wrong route get a lot greater.
Thanks, David. And when you start seeing yourself heading towards a dispute, are there any particular records you should be looking out for bringing together, or any ways you should prepare?
Of course. I think there are perhaps there are two parts to this answer. The first is, and most obviously, it depends what sort of dispute you're dealing with, and that's something that you're going to need to make an assessment of fairly early on. Is it? Are we looking at a dispute where there are going to be contested claims for delay? Are there going to be extensions of time, loss and expense claims, disruption claims? Well, if so, how are you going to make your delay claim? We all know about the different methodologies for proving entitlements to delay. Some obviously more theoretical, some more record-based than others. And we can have a very interesting, or possibly not, debate about the relative strengths and weaknesses of those methods. But I mean, there is broad consensus that, especially at the end of a project, when you're looking back retrospectively, a proper delay analysis should make some use of contemporaneous records to show how the project, or whatever it was in question, was put together. And so if there are no program updates, why not? What if you have no program updates? What other records can you use to show the progress of the works? If you're going to put together your as planned versus as built schedule, or however you're going to do it, you need to have a think about how you're going to evidence the build. I think lawyers, from past experience, lawyers don't always use photographs very well, and they're an incredibly useful source of information. The important thing, of course, is to make sure photographs are dated, that it's made clear what they show. The advent of metadata obviously makes that a lot easier, but they don't really fit very easily into the normal way that lawyers litigate disputes, at least certainly not the way they plead claims at the start. And it's very often, I've seen cases where lawyers have a little bit of an afterthought and think, oh gosh, well, there's this really rich record of evidence here that we've not really used. So I think use of photographs is something that that should be carefully considered. Separate sorts of claims. You see lots of contractors looking to bring loss of profit claims, head office overhead, these sorts of claims, which in my experience have been to differing degrees poorly evidenced. What sort of records are you going to bring to bear to show that you were turning away other work for the period that you were disrupted? It's not really enough to show that there were simple opportunities out there. you have to show that you were bidding for them and that you had to turn them away. Tribunals don't like these sorts of claims anyway, in my experience, and so you really are going to have to put something together that doesn't look like an afterthought, that looks like you were always intending to bring that claim. So that's perhaps that. We've talked a little bit about emails and how they are the devil. I think that's particularly difficult when you have what I regard as the Pandora's box of attachments within attachments, emails attached to other emails, and you really end up going down the rabbit hole trying to work out the structure. We talked a lot about document structure, and I think if you as a company can try to avoid that sort of practice from the start. Certainly one client that I work with always used to do this, and you used to end up with spiraling chains of emails, and just a simple working directive to everybody to make sure that they didn't do that meant that it became a lot clearer. It became a lot easier to find what people were looking for. So I think that's perhaps the sort of records. The other type of record we've already discussed, I think, fairly extensively, so I'll just touch on briefly. It's not a documentary record at all, but the human element. Who knows where the bodies are buried? Who knows where the documents are kept? And if you don't have that, you ultimately end up, from the lawyer's perspective, having to work it out yourself. And it, particularly with the way that document management platforms work, it's probably the equivalent of taking everything out of the nicely ordered files, throwing everything on the floor, and then starting to read the documents one by one, which I think we can all agree is not a good way of doing things.
Thanks, David. And Paul, what should you do if you get down the line, you start heading towards the dispute, and you find you don't have the records?
I think a party that doesn't have the records needs to bear in mind that if that party is asserting a claim, then they must, on the balance of probabilities, prove their case to the tribunal. I think they need to be able to provide as much evidence as possible to assist the tribunal, and if this can't be achieved, then in my view, the claimant's claim will most probably fail. I think the SCL protocol, it sets out in its edition 2 quite succinctly, basically saying, do not wait and see. It suggests that there's a use of contemporaneous analysis with regards to maintaining information, and parties should consider the types of records to be produced and information to be contained, who is responsible for producing and checking those records, the frequency of updating and the production of those records, who they should be distributed to, the format of the records, to ensure compatibility with any project-wide database, as we've already discussed, and the ownership and the storage and access to those records. And it also underlines, and I emphasise this, it needs good investment of time and cost and the commitment of staff resources. So in essence, if the parties don't have the records, then my personal view is good luck. I think your claim will fail. Or their claim would fail. But in any event, those records for me should show C's, which is cause, effect, entitlement, and substantiation. Thanks,
Paul. That's probably our last question before we start taking some questions from the audience. So if anyone does have any questions, do please type them in the Q&A box below. David, what about once you start formal dispute resolution proceedings? Any particular points that need to bear in mind?
Certainly. I'll touch on 2. The first perhaps follows on from what we talk about as the handover from the project team to the lawyers. And when the lawyers get the keys to the warehouse, the electronic repository of documents, and they're instructed to plead the claim or plead the defence or whatever it is, somebody's got to read those documents. And I think a particular trap that a lot of people fall into, I remember when I was at law school, I was asked, what's your case theory? So halfway through some cross-examination, what's your case theory? People talk about case theories, ultimately they're sort of idea of what happened. And the problem is that it ends up being a little back to front, because when you end up searching for documents, the normal way we do that is by way of keyword searches. And we sort of tailor those keyword searches to fit in with our existing case theory. And it's fairly easy to see that that may not present an accurate and certainly not a complete picture. The other aspect of that, of course, is that it's very often the junior members of the team who are tasked with looking at these documents. And I think this is something that's improved over time, but it used to be that they were quite siloed. People were always given documents from A to F, and then the next junior associate was given F to M or whatever, and just told to get reading. And leaving aside the obvious difficulties with that, it's important for the legal team in question to have the suitable sort of structure in place, that if a junior identifies something that gives them concerns, they are free to speak up. They don't feel pressured to go along with whatever the partner or the senior associate might regard as being the direction of travel for the case, because you never know. It may be that trove of documents that either causes you problems or gives you a silver bullet later on. That leads us on quite neatly to the second point that I was going to touch on, which is disclosure. And again, dispute resolution proceedings will be in all sorts of different fora, whether in arbitration, in court, potentially adjudication, and whatnot. And different types of proceedings have different approaches to disclosure of documents. The first and most obvious point is that we've talked about how important it is to have comprehensive records. What you produce is potentially disclosable. So it's all very well producing chapter and verse, but if they're going to cause you problems down the line, that's something to be aware of. And particularly this applies time and time again in relation to emails. In court, the traditional approach and what's called standard disclosure has been a feature of the litigation world for some years, and effectively requires all parties to disclose all relevant documents, both helpful and prejudicial to their case, save for the documents that are covered by the various forms of legal privilege. That itself has led to disclosure of all sorts of awkward emails on cases. I know that one judge of the TCC said when electronic document keyword searches were fairly new, so the best thing to do is to search for all the swear words. And it's amazing what you'll find in those emails. And anybody who's read the judgments in cases like Walter Lilly will know all about the perils of that. Things have been changing. They've been talked about being changing for a long time, and they actually have been changed somewhat in the business and property courts now, with the disclosure pilot, which is found in Practice Direction 51U. And it's a thrilling read, but it does have some quite notable consequences for the way that we do business, at least in courts. Sort of just touching on the main points, we've talked a little bit about preservation of documents. The Practice Direction actually formalises the duty on parties to preserve documents as soon as they know that they will or may become parties to proceedings that have been or may be commenced. And that's got rather more teeth than the current approach, which is the requirement to preserve documents as soon as litigation is contemplated. So it arguably arises earlier in time. And what's particularly interesting is that there's also an ongoing duty on parties, irrespective of any court orders that have been made, to disclose any known adverse documents to the other parties. Now, time will tell as to how much of an effect this has, and there's already talk that it might lead parties to sort of close their eyes to whatever might be underneath the lid by not making searches and adopting a sort of willful blindness approach. So taking the view that if you don't know about it, you don't have to disclose it. But I mean, time will certainly tell. Finally, the other aspect is this requirement of initial disclosure, which time used to be the case that you would plead your particulars of claim or your defence, and then the parties would give disclosure down the line. now you are meant to set out an electronic list of documents that is served together with your particulars of claim, together with copies of any documents that are not in the possession of the other party. This is subject to various limitations based on value and size of cases, and it does seem initially to me that it sort of it seems to target the wrong cases, because disclosure isn't normally required if it will lead to the provision of more than 1,000 pages or 200 documents, and so it seems to me that actually what it's doing is targeting those low value smaller cases and adding an additional requirement of complexity and of course cost, and perhaps not focusing on the larger cases. Finally, the practice direction contains provision for the court to make a range of, this is a menu of disclosure options that have been talked about in the past, from standard disclosure to enhanced disclosure to a more limited form, more akin to arbitration proceedings, which again in theory allows the court or tribunal to tailor the disclosure to the case. But that again seems to carry some difficulties to my mind, because one party very often seems to think that the bodies are buried somewhere on the other side, whilst the other one is rather less fussed about the documents that come from the other. So you're going to see battles as to the appropriate form of disclosure order, which again is just another layer of cost and another layer of complexity, all before you find that the court ultimately makes the same order that it would have done in the first place anyway. So time will tell, and there's plenty more in there, and it is worth a read, but it's certainly very important to be aware of this pilot scheme, because I suspect that it will, whether in its current form or in some very similar form, be a feature of our lives for some time to come.
Thanks, David. We've just had a question come in. Where can they find the practice direction that you're referring to?
On the government website, actually very helpfully, you have to be a little bit careful because they're not always entirely up to date, but on the justice.gov website, if you search for practice direction 51U, you will find it on there. There are some introductory provisions explaining its application, which cases it applies to, and then of course the subsequent provisions that set out the specific features.
Brilliant. We'll provide a link to that with the write-up that we send out to all attendees as well. And another similar question in a similar vein, Paul, I'll pass this to you because I think you've mentioned a couple as well as we've been talking. Are there any good publications available that can help the attendees work out which records they should be keeping?
I personally think everybody should have a copy of the SCL protocol. I think that's a really good start for 10 in terms of determining what records should be maintained. I think, and we've already mentioned this, I think the parties to a contract really should from the outset agree between them what records should be maintained, even if it's not a contractual requirement. Start off on the right foot and have that information written down somewhere, so at least parties know exactly what should be maintained and how and who it should be given to. I think that will be also a good starter for 10. There are lots and lots of publications out there. There's lots of people writing about it. There's lots of webinars and blogs on record keeping. But as Max Abraham said, records. That's what needs to be maintained. So it's how we go about doing that.
Thanks, Paul. And I think earlier as well you talked about this CIOB guide to time management. So that's another one that's quite useful. I think that's all the questions we've got in. Thank you all for joining us, unless there's anything else in the next minute or so. It's been great to have you all online. Paul, do you want to say anything before we close?
I'd just like to thank the attendees for joining us today, and in particular thank the panel, each and every one of you. Thank you for your time. It's been informative. I hope the attendees have found that useful as well. There will be a webinar link on our webpage, and on that basis, I thank you all, and I wish you all a successful day. Thank you.
Thank you. Thanks, everyone.
Bye-bye now.